You're ready to file your trademark application, but the USPTO is asking you, what's your filing basis for each of your classes? What does that mean? Hi, I'm JJ, trademark attorney for over 15 years, and in this video, we're going to tell you what the USPTO actually means when they say filing basis for each of your classes. You can have multiple classes and multiple filing bases, and so it depends on how you're using the mark and how you want to actually have your application or trademark application registered. So let's begin. So what is the trademark filing basis? The trademark filing basis states that each of your applications or each of your classes has a certain basis for it to be registered. Either it's 1A, which means it's currently in use in commerce, or it's 1B, that you intend to use the mark in commerce, or it's based on a 44E foreign trademark application that you filed. Sorry, that's 44D. And 44E is a foreign trademark registration basis, or you're taking advantage of the Madrid Protocol and you're reciprocating protection from another country. In that case, you'd be using 66A. In this video, we're only going to cover the benefits, pros and cons of 1A or 1B application. In another video, we'll cover the 44D, E, and 66A. Let's begin. So let's see. We'll start with all services and goods must be in use at the time of filing. So for 1A applications, the answer is yes. So everything you listed in a 1A application must actually be used in commerce, and you're signing an affidavit stating that these are actually being used in commerce. Now, the benefit of 1B application is that you don't have to list everything that you are using in commerce. In fact, you're saying, I intend to use in commerce. So you can overfill these. You can have as much different services or goods listed in each class that you want, and you're not limited legally by what the affidavit and what the application says. But however, for 1A applications, it must be limited and restricted to the services or goods that you are actually using the trademark in commerce at the time of filing. All right. Are there later fees in the trademark application process? In the 1A application, no, generally not. Assuming that there are no issues, no other outstanding issues with the office action or third-party oppositions, and going through the normal process, there are no other fees. So 1A applications already have the specimens submitted showing the examiner how you're using the mark in commerce. So there's generally not any extra fees. However, 1B applications do require a statement of use filing, and that is per class. So there's additional fees later on in the process, but that's really not required until almost a year later after the application has been filed. Main reason for that is it's an extra submission that must be done by the applicant and an extra review by the examiner that needs to be done at a separate time. Can a single application contain both A and B, 1A and 1B filing bases? Yes, in fact, a single application could have multiple filing bases, especially if it's a foreign 44E filing, and it could also include a 1B application filing basis as well. So yes to both of these. So what some of the other benefits? In terms of filing a 1A application, is slightly faster because you're skipping over the statement of use filing and you're skipping over the examination of that specimen later on in the process. It's not examined together with everything else from the examining attorney once they're assigned to your case. The benefit of a 1B application, however, is that it's already filed and your foot's already in the door. And so during this time, because it takes approximately 8.5 months after filing, before the examining attorney reviews it, you actually have this time to start developing the product or service and actually marketing it and getting it ready in commerce. In other words, you don't have to have all that up front and ready before you actually file the trademark application. And in some cases, the expenses to go to market, either a service or goods, outweighs the filing of the trademark application. And so in this aspect, what you're doing here when you're filing in a 1B application is already getting it vetted up front, examined by the USPTO and also third-party opposition. You're going through the whole process before the specimens are required. And so it saves a considerable amount of resources, time, and energy in developing these products, and you have a good idea whether or not it's going to get to registration by the end of this process. So that's it. That's all for this series. So if you have any further questions regarding filing bases, feel free to contact us, email us, and also please visit our website, tmtelegram.com. That's TM is trademark, telegram.com for more trademark tips, tricks, and news. Until next time, keep your brand safe and protected. Have a great day.